All right. Do you want to start introductions or? Oh, you're eating. Allison's eating. So I'll do introductions first so you can finish your lunch. Welcome everybody. I think this is getting repetitive because I think I've seen everybody at a session of some type, but I'm Kevin Love. I'm a lawyer in the community law program at the Community Legal Assistance Society. Wonderful to see everyone at this this session, which of all the sessions terrifies me because it's the hardest and most technical and hardest to untangle, but important stuff for sure. So,
is my mic on? I'll just yes. Technical problems to kick off the session here. Good morning, everybody. I think like Kevin, I've met you all before. My name is Allison Ward. I'm also a lawyer at the Community Legal Assistance Society, where I run the Community Advocate Support Line program. And that makes Kevin my colleague. And we don't often have the opportunity to present together. So it's a pleasure to be here with all of you today. This is pitched as a session for new advocates. But I agree with Kevin, this is actually quite a difficult topic because you're just learning about, well, what is welfare? What are the criteria? What is PWD? What is the criteria? What's CPP-D? What are the criteria? And this session says, well, how do all of those things interact? So I also realize there's a mix of levels in the room. I see people who started last week. I see people who started over 20 years ago, and you're welcome to be here. We're going to hope that there's something for everybody in the presentation. If you don't understand it all, that's probably normal if you're a newer advocate, but the PowerPoint is up on Sched, and maybe in 6 months when you've been working a bit longer and you go back, you can take a look at it. What was it that Kevin said about EI and receiving CPP at the same time? At least the information is there. And there will be, I'm sure, useful parts for everybody. At least some of the session should be useful, I hope. This is also a hybrid session, so there's an online audience, and we'll be asking for questions from the online folks as we go through too.
okay. Do you have the clicker? You're the official clicker? Okay. So what we will do, well, Allison has basically said what we'll do, so I won't repeat it. But you learn about these benefits in isolation, in silos. But the reality for your clients is a lot of them are accessing a whole bunch of these benefits, or potentially could be, and then they all get mixed together, and the dreaded word clawback starts to rise, or it could be worse. It could disqualify. So we're going to try to untangle a lot of that with the goal of putting the most money into your client's pockets, right? That's what we want. Most money so your client can afford to live and meet their basic needs, which is what a lot of these benefits do. All right. So for starters, this PowerPoint is going to be littered with acronyms, absolutely littered with acronyms. And I apologize. I'm going to try to catch myself and not start defaulting to acronyms because not everyone knows them, right? So, but I just popped this up here. So if we get lost, if you just give a quick skim, it might give you a little bit of an idea of what we're talking about. But the other thing with this slide, right, is it shows you the full breadth of the benefits. Like, look at all these things. I mean, like, there's so many different benefits that your clients can be accessing. So this sort of gives you a bit of a starting point on the landscape and why everything is so complicated. All right. So the other thing, just to get out of the way at the outset, is disability. Because really there's two things your client can say to you that you have really no idea what's coming. The first is, I'm getting a pension. And okay, that could mean a lot of different things. The second thing is the word disability, because they have a meaning for it in their own life. As it impacts them, but then they go and interface with these benefit systems, and the system has a very different definition of what is a disability and what it's going to cover and how it's going to cover it. So I won't read it verbatim, but this is just on this slide an example of how the different some of the different benefit schemes define disability differently, right? So for PWD, we're looking a lot at activities of daily living, right? Like that's kind of what we're getting at. It's not necessarily work-based. You go down to CPP-D, and it's got a very specific definition: severe and prolonged, where severity is assessed in terms of long-term employability. Is the person incapable regularly of pursuing any substantially gainful occupation? So, all this to say, this can be frustrating for clients, right? Because they have a sense of self and how they view their disability, but then that's not how the system see it. And you've got to translate that into the way each of these schemes talks about disability. And even going further, again, there's different aspects of it. WCB as an example, I get this all the time. Clients saying, "Yeah, but I was injured. I was left with a disability. I cannot work." And then you got to go through the yes, that might be so, but WCB is only there to cover one type of disability, and that's disabilities caused by work accidents. It's not a general insurance program. There's also different focuses in terms of the time. EI, although someday they're going to actually bring it into force and it's going to go up. EI is designed to deal with short-term sickness, right? A lot of frustration from clients because they have disabilities, illnesses that go a lot longer than 15 weeks, and EI doesn't care. It's over when it's over. Long-winded way of saying that this one word disability really creeps into a lot of different schemes, and you've got to untangle how it interfaces for your client in each of those benefit systems.
All right, I'll just add a couple of words to what Kevin said. So it's going to be very confusing for you as new advocates to understand what the definition of disability for is each different benefit scheme. And of course, you have to unpack that and help your client understand that. I'm just flagging that it's also difficult for doctors to understand. And in many cases, part of proving that your client meets the eligibility criteria for, say, CPP-D or PWD is you need something from the doctor. And, communicating directly with doctors has a true value because, if you say to your client, go see your doctor and get a note saying that you're disabled, the doctor can come back and say, we don't know what they're going to say. There's very specific definitions of disability that need to be fulfilled depending on the type of benefits the client is applying for. And the more you can communicate with the doctor to help the doctors understand those eligibility criteria, the more likely you and your client are to get medical evidence that actually jives with the definition and the threshold that you have to meet. I'm going to move on now to a section specifically to do with clients on income or disability assistance with the Ministry of Social Development and Poverty Reduction. Generally speaking, the ministry is considered to be, in most cases, a payer of last resort. So generally, most other types of benefits are deducted from welfare. That's a gross generalization. And there are complicated rules about and exceptions to rules whenever we're dealing with ministry issues. So I'm going to run through some of the most important of those with this wonderful chart. So what we're highlighting is not like, different types of income. For those of you who do a lot of welfare issues, you might be thinking, oh, is an inheritance exempt from welfare? What are the rules about other kinds of income? Here in today's session, we're looking at different types of categories of benefits, broadly speaking. And I saw someone taking a photo. Just to note, the PowerPoint is uploaded to SCED. So hopefully you're free too. That's fine. Oh, okay. But it is on SCED if you're having trouble in the back of the room. If you don't have a tablet or something, you can find it there later, but whatever you need to do works for us. So looking at other kinds of benefits generally, first category is EI. There's quite a bit of confusion, I think, when it comes to EI and how it's treated by the ministry, because of course there's different categories of EI benefits and they're treated differently. EI pregnancy benefits, parental benefits, compassionate care for a critically ill child. Those benefits are treated as exempt income and exempt as an asset for all forms of welfare. That means those forms of EI benefits are not deducted from welfare benefits. They should not affect the person's ongoing eligibility for welfare in any way. Of course, like all other forms of income, any income the client receives, if they're on income assistance or PPMB, must be reported to the ministry. And for folks on disability assistance, any change in income needs to be reported. But you can't go wrong with over-reporting. Even if there's no change, someone on PWD can just report, yeah, I got my EI parental benefits again, and they can't go wrong by keeping the ministry as apprised as possible about their income situation. So EI regular as sickness is a totally different kettle of fish. EI regular and sickness benefits are treated as unearned income for all categories of welfare, and they are deducted dollar for dollar from any kind of benefit checks, which a lot of people see as being quite unfair, particularly folks on PWD with a large earnings exemption who may qualify for EI based on their earnings. We'll talk more about that, I think, later in the presentation. But the truth,
we only have one mic, so I can't just jump in.
we have two mics.
No, it's good. That's really unfair.
Yeah, it's very unfair. And I know GABC in particular has been trying to do some sort of more political lobbying and advocacy about that issue to see if we can't get some changes made. Another category of benefits that interacts with welfare is CPP. And again, there's different forms of CPP benefits. There's CPP disability, retirement, and early retirement. Those are all treated the same by the ministry. Those three are all classified as unearned income and deducted dollar for dollar from all forms of welfare. It used to be not too long ago, prior to January 1st, 2020, the ministry could actually force people to apply for CPP early retirement, and then they would deduct it from their checks. So you might have clients who think that that's still the case. You can reassure them that it's not, that it's changed. They are not forced to apply for early retirement. And in almost 100% of cases, they shouldn't be. It's not in their financial interest. So we won't be seeing those early retirement forced applications anymore. Final category of CPP is orphans benefits, disabled contributors, child benefits, so benefits destined for children of CPP contributors. Those are treated as exempt income for all forms of welfare. And the reason for that is that they're considered to be akin to child support. They're for the benefit of the child, not the adults in the family unit, and so they are exempt income. Similarly, we also have an exemption for family law child support paid by the other parent. Again, that's a relatively recent exemption. It used to be the case that child support was deducted dollar for dollar from welfare benefits. And there may be clients out there who think that that's still the case, and they may be hesitating to apply for welfare because they think, oh, I have $1,000 a month in child support. I know in their mind, they can't get welfare. That has changed. When did that change, Kevin? It's 5 or 6 years ago. It's 2016, I think, maybe. So it's good to know about these historical things for some reasons, but the important thing to know currently is that it's fully exempt and not deducted from any kind of welfare. Spousal support is just the opposite. It is considered unearned income, and it is not exempt as an asset either. So it is fully deducted from all forms of welfare benefits. Sometimes in family law, there's a negotiation for a lump sum of spousal support where that can happen for a client. The other parent, the former partner, perhaps has an ability to pay a large lump sum. That can be to the benefit of the person on income assistance or disability assistance, because rather than having the full amount deducted from their benefits per month, generally speaking, a large lump sum is considered income only in the month that it's received. So they may be off benefits for 1 month if the lump sum is bigger than their benefit rate. But in the month after receipt, it would be considered an asset. It may be under their asset exemption level. And it may be, if it is over their asset exemption level at the time, there may be other ways to try and exempt it. by putting it in a trust, by using it to buy an otherwise exempt asset, like a family home in which you live, for example. So that's sort of beyond the level of detail of this session, but it's important to know that that can also be an option.
And actually, just before we go on, sorry, is it okay? I just want to go, I'm going to go back for just 1 sec. Like in terms of money, some of you might be saying like, why? Like why is it this way? Often there are no answers, but the one thing with EI and the child support, spousal support, most of the exemptions were based on gender-based discrimination complaints because of the disproportionate child responsibilities that fall on women. So if you're wondering why EI, pregnancy, parental and compassionate care for critically ill child, managed to get exempt, it was a response to that. We know that, well, obviously all pregnancy benefits, but also as of about 5 years ago, 90% of parental claims were taken by women, only 10% by men. They brought in some measures to try to change that, but that was the reason. But that didn't get us out from under the other ones that don't have at least an obvious gender dimension. And same here, I believe the child support was exempted again because of a charter, a gender-based charter challenge to the idea of clawing back child support, given the disproportionate care responsibilities that fall to women. So that's how, just in case you're a history buff for this kind of stuff, that's kind of how we got where we are. Yeah. Yeah, sorry. And the question was in terms of the impetus for the change, is there a chance we'll get further change based on new political parties in power? I think, yeah, I hope yes. I'm not sure. As Al,
Or have changes
Yeah.
rolled back. Yeah. I would say, yeah, none of these things are written in stone, that there's the possibility for further changes. You know, a lot of the exemptions that we're seeing here are the result of work done by different advocates and public interest lawyers. So yes, you know, there can be further exemptions that are carved out, often as a result of a human rights complaint, a court case that's brought. But most of them are in regulation, and regulations can be changed in order, but in council, it doesn't need even to go through the legislature. With a change of government, things can change as well.
Yeah. And there's good policy arguments behind further changes, like spousal support. Like you're chasing spousal support that hasn't been paid. What good does it do you? Like if it's just going to be deducted. One of the themes we will come back to is what Alison mentioned, is that lump sums are almost always better than ongoing benefits. It's weird, but they are. But you know, like what incentive does someone have to chase down? It's running to stand still. And with EI, I think again, Disability Alliance BC, good on you for leading this charge. All EI should be exempt because you pay for it. Every bloody paycheck you get, you're getting that deduction. This isn't money the government is giving you. They haven't funded the system since 1990. So, you know, you're paying for it, but then you qualify for the benefits you paid insurance premiums for, and you get no farther ahead. So it's silliness. But anyways, we're not here for my random rants on why things are bad. Is this a slide we're on? Or? Ah, there we are. Okay. So, yeah, while we're talking about not making sense, it's about time to turn to WCB. So WCB, again, because as Alison talked about, the annualized earning exemption means a lot more people on disability assistance are good, or there's reasons to get into the workforce. That has the flip that people are going to have workplace accidents and possibly qualify for WCB. So in terms of the treatment here, if you're on income assistance, it's unearned income and it's deducted dollar for dollar. If you're on disability assistance, it's considered qualifying income, which means it kind of gets treated the same way as your earnings would. So as long as you stay under that annualized earning exemption, AEE is annualized earning exemption. As long as you stay under that, you get your benefits. Now, WCB permanent disability benefits, often called that helpful word pensions, they are deducted dollar for dollar from both. That doesn't necessarily make sense, but it is what it is. But this brings us to another one of these themes, again, about lump sums. Lump sums are almost always better. And so we're going to come to, I don't know if it's the next slide. It is the next slide. And so WCB has two kinds of benefits. Use the example, you know, I hurt my knee. There's a period of time where I'm healing, I'm getting better, I'm recovering. It's temporary. The situation is temporary. At some point, ideally, my knee will fully recover, but maybe it doesn't. And now I'm left with a permanent impairment. There's something permanent. It's not getting better. It's not getting worse. It just is. That's when we start talking about permanent disability benefits through WCB. There's the interesting thing about WCB permanent disability benefits. So there's two ways they can do it. One is to give you a check every month. You just get a monthly check. It just comes in. That's one way they can do it. Second way they can do it is to get out their bean counters, do a bunch of math, and figure out, okay, if we take all this money that you would get or we expect you to get for the rest of your working life, age 65 or longer, if the benefits continue, we can figure out what we need to give you now as a lump sum. And for smaller WCB pensions, they commute. What's the, I can't remember what the threshold, I think it's 5%. Is it, what's it? 10%. 10% or $200. They're going to, and that's the word, commute. Commute just means take it, put it into a lump sum, pay it out once. That is way better for your client, right? Because that's going to blow out 1 month of their benefits. But as long as they're under their asset limit, the asset limit for disability assistance is 100 grand. So as long as it's not a huge amount, they're good. They lose 1 month of benefits, but they continue on. If they pay that pension out, if WCB pays out the pension monthly, well, then it's coming off every check. So one of the things, you know, Alice and I were talking about, that's an interesting advocacy opportunity, is to start pushing WCB to try to commute pensions. Even outside of those automatic commutations, WCB has discretion. And it's up on the slide here. For example, someone wants to pay for education, start up a business. Show that the payment of the lump sum will improve your chances of a secure income over the long term. And these are the examples given by WorkSafe, but they don't speak to our clients really. And the one thing that I've had a heck of a time trying to get WCB's mind around is if you pay it out as a lump sum for someone on disability assistance, you're actually improving the security of their income over the long term because you're avoiding that deduction. We haven't gotten that far, but I think we should keep pushing. So if you get these, if you do see clients who have WCB pensions, push to commute it. You may want to think if it's going to get up over 100 grand because now you got an asset limit problem, right? But otherwise, you may want to take a stab at trying to get them to wrap it up, pay it out as a lump sum on the argument that you're actually protecting their other income. You're protecting it. Yeah. Did I miss anything on that?
Yeah, I would just say that not only would the client then be receiving full PWD benefits, so yes, there would be a secure income over the long term, but they would actually be able to benefit from the WCB award as a lump sum. And even if the award, if the person's on PWD, even if the award is over $100,000, there's ways to manage assets so that it would have a minimal impact on their benefits. So I would say regardless of the size of the commutation they might be eligible for, if they're on disability assistance, it can be a very good idea to push for commutation. I'm planning a follow-up workshop to conference to do with welfare and tricky asset issues. So when I say there's other ways to manage assets over $100,000, that workshop will address some of those ways. We just don't have time to do it.
Nice teaser.
Yeah, teaser.
I see a couple of hands up. So I can just, do you want me just to repeat the questions or is there a mic or what? Okay, I'll just repeat the questions. So, okay. Yeah. it only applies to people who are permanent. Oh, sorry, the question, I said I'd repeat the question, then I didn't. The question was, does this apply to people who have permanent disability awards through WCB or temporary disability benefits? It only applies to permanent. Temporary, to the best of my knowledge, is always paid out month to month. But again, for DA, for disability assistance, you're okay because it's good up to the annualized earning exemption, those benefits. So you should be okay anyways. The permanent are not, and that's where the problem lies. So this commutation stuff only applies to those permanent disability, lifelong WCB pensions. Yep. Yep. Yeah. The question was, can you make the pitch to commute the pension even after the client has gotten the pension for some time? And yes, I think you can. I don't see any reason you couldn't. And in fact, I think they will do it based on changing the client's circumstances. You know, like if one of these factors on the slide comes up, they'll do it anyway. So
yeah, I think it's pretty rare that commutation applications go in for our client basis. Like procedurally, you can Google it. You'll find there's an application form you can request. You need to submit your plan when you're sending in the app. Like, what is it that you want to do with the money? Why do you think it should be commuted? And so there would need to be sort of a detailed argument about why it should be commuted, along with any other information. I mean, maybe one of these other things would apply to your client as well. Maybe they also want to use the money to help pay off debts that they incurred before their injury or to pay for education. I just want to say one more thing about WCB. I'm going to go back to the last slide. This slide. Just to say that letters from WCB are very unclear. They use template letters. And so we know that temporary wage loss benefit, temporary disability awards fall under your earnings exemption if you're on disability assistance. But clients often don't know what they're getting from WCB. And even if you say, well, just give me a copy of the letter you got from WCB, generally, it's not clear what kind of benefit they're getting. So again, as an advocate, it can be really helpful if you become the liaison to communicate with WCB to say, look, I just need clarity. Like, you're a person. Tell me what kind of benefits this person is getting. Is it temporary disability under section 91 or 92? I put the section numbers up there because those are the section numbers you'll see in the Employment and Assistance for Persons with Disabilities regulation in the annual earnings exemption section. Is it benefits under section 191 or 92? And they say, oh yeah, it is. You say, great. Can you write me a letter saying that? Get that for the client. Client takes it to welfare, and Bob's your uncle. Those benefits should now be exempt. But their letters are super unclear.
they are really unclear.
Okay.
All right. So we'll break. Oh, we got to.
Yeah, got to catch up here.
There you go. Okay, so we'll do a quick. We'll pause just to do a quick fact pattern, so you don't have to listen to us for this this whole time. So again, the purpose here isn't to necessarily get the right answer. We're trying to explore what kind of information do we need to gather. What does our information gathering process look like from our clients? So Bruce has PWD, collecting disability assistance, supplements his income working in a fast food restaurant. Bruce was laid off and wants to know about his options. He's worried about money because his wife normally works part-time, but she's pregnant and due next week. So she recently stopped working too. What kind of questions would you ask Bruce, and why and what are you trying to get at? Yep. Right. The suggestion was to ask Bruce if his partner is going to have enough hours to qualify for EI, right? And that's relevant because would EI be deducted from PWD? Yeah. Yep, I think that's exactly it. So the answer there was that pregnancy benefits would not be deducted, but the regular benefits that Bruce might be entitled to could be. Yep. Anything else you'd ask Bruce? Yeah, you'll want to explore with Bruce if he has enough hours for EI. Yeah. Okay, so here's a little more information you get from Bruce. Bruce tells you he has the PWD designation since 2016. He's been working for Johnstown. I guess that's the company, consistently for about 2 years. He doesn't work much, roughly 9 hours a week, and he currently earns $15.65 an hour. What would you tell Bruce? Sorry, we're jumping into kind of the depths of the EI law here, which we maybe didn't go over specifically, but yep. Yes, so we are back now. EI, just so everybody knows, EI you qualify based on hours, not weeks, not days, hours. So you can work, and the threshold varies from 420 to 700 right now. Most places in the province, as I surprisingly learned, Elsie told me, are now 700 hours. So you can work 700 jobs for 1 hour, or one job for 700 hours, it doesn't matter. As long as you get over that threshold, you're fine. So part-time work, 9 hours.
I did the math. It's 468 hours a year. So it's a little bit of a trick question because we didn't recently cover the hours issue. Under some of the COVID rules until September, you could across the country qualify at 420 hours. So he may have qualified under the COVID rules, but currently it's 700 in BC. He doesn't meet that hour, the insurable hours standard. But as Lisa just said, his regular EI would be deducted from his PWD in any case. So he would be no further ahead if he made his own EI claim. But we would want more information about the wife because she's due any day, and we would want to find out if she meets the contributory requirements for insurable hours for pregnancy and parental benefits.
Yeah. And sorry, did you have a comment? Yes, and that's a great question. The suggestion there was to ask what region Bruce is in, because EI hours, to make matters as complicated as possible, BC has about 6 or 7 regions, and the number of hours you need to qualify for EI depends on what region you're in. So it could be different if you're in Fort Nelson versus in Vancouver. It could be very different. But as Allison mentioned, I think what this fact pattern really illustrates is your attention probably needs to shift to Bruce's partner, because she's the one who potentially has a big EI claim that will be exempt. And one other important thing in terms of benefit interactions, PWD, of course, disability assistance is based on the family unit, right? Family unit. EI is not family unit. Yes, there are some interactions where there are maximums that 2 partners can take for a given child or what have you, but people qualify independently and people are entitled to EI independently. So although they're a family unit and the ministry is going to see the money coming in as all the same, EI sees the 2 of them as individuals with individual claims. Yep. Yep, a great suggestion. Also explore childcare benefit. Back to that web of all the different benefits that are available. So.
Yeah, and there's no slide about the Canada Child Benefit, but it is fully exempt for everybody on all forms of welfare. So great suggestion. Okay, are we done with Bruce for now?
We're done with Bruce.
All right.
Oh, I remember this scenario. That's from the river. Got a job working construction
What
for
was
the
your-
Johnstown company. Okay. All right.
We taught a version of this workshop together in 2020 when there were all the pandemic benefits and we were trying to figure out how they interacted with all of the regular sort of benefits we have now. And Kevin drafted most of the fact patterns. So he's just twigging to his own joke.
whatever song was on the radio. The River by Bruce Springsteen.
Yeah. All right. So I'm going to talk now a little bit about the very complicated and interactions between PWD and CPP-D. In a way, I shouldn't say it's very complicated, but there's a lot of ways and fact patterns in which things can become quite tangled. Just to start at the conceptual level, as we've said, PWD and CPP-D define disability very differently. So to qualify to be disabled for the purposes of CPP disability, you need to have a severe and prolonged disability, where severity is defined as meaning that you're incapable regularly of pursuing any substantially gainful occupation. Basic idea there is disability for CPP-D is defined in relation to your ability to work, whereas we know that for PWD it is not. It is defined in terms of the duration of the disability and its impact on your ability to do daily living activities. Work does not factor into that definition anywhere. Another difference, of course, is that CPP is a contributory scheme. In order to qualify for CPP disability, you have to have made enough contributions through work recently enough to the date of your onset of disability. The general rule is you have to have made valid CPP contributions in 4 out of the most recent 6 years prior to the date you can show you became disabled, according to the definition of disability in the CPP legislation. In terms of the interaction between PWD and CPP-D, it's really important to know that the ministry has a section in the EAPD, the Employment and Assistance for Persons with Disabilities Act and Regulation, that enables them to require somebody to apply for CPP disability. So you can be, if you're on PWD, you can essentially be forced by the ministry to apply for CPP-D. If you choose not to, that can jeopardize your disability assistance benefits. So that can be a very harsh situation. So as advocates, you may see people who come to you for a CPP-D application saying the ministry told me I had to apply. And as much as the reason that they force people to apply for CPP disability is because CPP disability is deducted dollar for dollar from all forms of welfare benefits. So ultimately, it costs less for the ministry. They pay out fewer dollars overall. It saves them money. I want to talk a little bit about this idea that the ministry can force you to apply for CPP disability. That's just a fact. So it leads to some kind of advocacy tips. So generally speaking, rather than waiting for the ministry to ask somebody on PWD to apply for CPP disability, it's generally best for the client to be proactive and for them to apply on their own initiative. Now, the reason for that is because if it comes to the point where the ministry is telling them they need to apply for CPP disability, the ministry under its legislation can also require the client to sign, it's an assignment of benefits. So it's a form called a consent to deduction and payment. I've jumped ahead to another slide, but that's okay. I'm going to go back, which it once signed, the effect of that form is that it will mean that any retroactive CPP disability the person may be entitled to won't go to them. The retroactive benefits would be paid over to the ministry. In some cases, retroactive CPP can be quite a lot of money. You can get 11 months of benefits retroactively prior to your date of disability, and the client would much prefer, I'm sure, to have that in their own pocket rather than it going to the ministry. So it can be a very good idea for the client to apply on their own initiative because it will ultimately put more money in their pocket. Lisa? Yeah. Great. Segue to the next slide, and I'll repeat your question there. So the question is, if somebody wants to apply for both PWD and CPP disability, is there one order that's smarter to apply for them in than the other? And yes, there certainly is. It's generally best for the client to apply for the PWD designation first and get disability assistance before applying for CPP-D. The reason for that is if, when you're on PWD benefits, there's other things that come with that. You have the ability to apply for crisis supplements. You have an earnings exemption. Another thing that you have is access to Schedule C health benefits of different kinds. So if somebody is on PWD and then applies for CPP disability, and let's say they had quite a long work history and they earned a fair bit of money, and their CPP disability rate ends up being higher than their PWD rate, in that case, they're going to become financially ineligible for PWD once their CPP disability starts. It's say it's $1,200 a month or above. It's higher than the single person PWD rate. I'm assuming they're single. In that case, because they were on PWD first, they'll keep what's called medical services only status, which means even while they're only on CPP disability benefits, they still have the ability to go back to the ministry and ask for some Schedule C health benefit stuff. So that can be very valuable, particularly depending on what kind of disability they have, or as their needs change, as they age, and they may develop, mobility issues they didn't have when they were younger. So medical services only includes medical equipment, scooters, wheelchairs, canes, medical supplies, dental coverage, which is very expensive these days, optical, medical transportation to other doctors' appointments, and some paramedical coverage for physio and chiropractor. It doesn't include a few things in Schedule C. Diet supplements, monthly nutritional supplement, or natal supplement. So and then the slide repeats the point I made earlier, is that if the retroactive benefits from CPP can go back 15 months, although with a 4-month waiting period for benefits, there's a maximum of 11 months payable. So if you delay your CPP application date in order to apply for PWD first, theoretically, they may lose out on some months of retro just because they're going to be applying for CPP-D a little bit later than if they hadn't stopped to apply for PWD first. But I think financially, the value of having medical services only status as a result of applying for PWD and then CPP-D is almost always quite high. However, you may have clients that come to see you and they're already on CPP-D, and maybe their CPP-D rate is lower than the PWD rate. And so you say, oh, do you know PWD these days is $11.58 and 56 cents, I think. If their CPP-D rate is lower than that, they can then apply for the PWD designation so that they get topped up. They get a little bit of money from the ministry to make sure they have an income level equal to the PWD rate. If that's the situation, your job's a lot easier, because for folks who are already on CPP-D and want to apply for PWD, there's a simple 2-page application form called the designated class application. Sure, I'm just jumping over a slide because I dealt with my issues in the reverse order from the slides. So we'll just jump ahead a little. Yes, question? Oh, online.
If they become financially ineligible for PWD due to higher CPP-D, will the ministry still take the retro?
The ministry can only take retroactive CPP-D if the person has signed consent to deduction and payment form. So it would depend whether they signed a consent to deduction and payment form. And of course, retroactive benefits are only taken by the ministry if the person was actually receiving PWD benefits for all of the months that the retroactive CPP benefits are paid for. I think that answers the question. And now we have another fact pattern, and I'm going to give it back to Kevin.
I clearly had a Bruce Springsteen playlist on 2 years ago whenever I wrote these. If I have Rosalita in this one. Okay, so Rosalita was diagnosed with a very serious long-term illness. She's been off work for a while now. She kept hoping things would get better, but now she's not so sure. She has no income and needs financial help going forward. So what types of questions would you want to ask Rosalita? Yep. Always a good question. So the suggestion was to ask about short-term and long-term disability benefits through the organization she worked for. And that's a great point. We were focusing on government benefits, but it's important not to lose sight that people who are fortunate enough to have those benefit plans should certainly explore them because they can be quite beneficial. Well, what are you gonna what benefits could you be looking at here for Rosalita? Sure. There could be a potential for EI sickness. There might be a bit of a problem because of the amount of time she's been off. You're supposed to apply for EI right away, which might, be another, you may want to know what a while now means. Like how long is that? Yeah. So the suggestion there was to ask about why there was the delay taking action to apply. Any other benefits you could consider for Rosalita here? Do we have to give them a hint and go back a slide? Sure. Go. Yes. So the question was, how old is she? But you also made the suggestion about CPP disability. Yeah. If she's off work and has been for a while, there is a chance that she would qualify for CPP-D if the illness is serious enough, right? So you'd probably want to explore, or the disability, you'd probably want to explore a little bit more about the severity and whether she sees this as temporarily being unable to find work or truly not being able to return to the workforce. That would open up CPP-D. But what about like she needs money now? What program could we be looking at? Could be some hardship assistance in the short term. And if she's got disabilities, right, of course, you could be looking after that at disability assistance. Yeah.
I would want to know about her family situation. I mean, she may have a spouse who's working full time. We simply don't know. So do you need to suss that out?
Yeah. And
I was saying I would want to know more about her family situation, whether she had a spouse who might be working, and we don't know about her financial situation of the family unit overall. And that's important to know before we can say, oh, maybe she's eligible for some benefits from the ministry. Let's jump ahead and get some more information here. So we asked her some questions. Kevin, tell us what you said.
Sure. And the one thing that you're going to want to know, well, the answer's up there now, but how do you assess entitlement to CPP disability? What are you going to need to know? Yeah, exactly. The suggestion there was to ask how long you've been working. Have you been making contributions, right? CPP-D doesn't just pop out of nowhere because you're hurt and you've worked for 1 year. You have to, as Allison mentioned, have made those. What's that, sorry? Yeah, oh yeah. Now we're going down that rabbit hole from the last presentation. Yeah. You need to know if she's made valid contributions to become entitled to CPP-D. Yeah. No, there's no age, but it gets correct me if I'm wrong, it's 65.
It's 65. You
Yeah.
can't receive CPP-D after 65, but before 65 you can apply.
Yeah. So it's unrelated to age except for that age 65. And there's some weird stuff where people take their retirement pensions early and then qualify, but that's way beyond the scope of what we need to to go at here. So, all right. So Rosalita tells you she went off work because of illness in January 2020. She tried going back to work in February 2021, but that only lasted about a week before her doctors told her to stop. Before getting sick, she had worked for 20 years, earning about $55,000 a year. She has $7,000 left in the bank. She is worried about her future. She is 50, single, and has no kids to help her. What would we be telling Rosalita here? Yep, she could definitely apply for EI. She might have so EI, generally you have to apply within 4 weeks of being laid off. This is going to require a monster of an antedate to get back onto EI, but you know, that might be possible. Let's say the EI doesn't pan out because she's late. What other benefits could we be looking, and what order might you want to do things in? Everyone's so quiet. Yep.
Okay, I'm not going to repeat all of that, but what I'm getting from what you're saying, just in the interest of time, you need to figure out, would she meet the contributory requirements for CPP disability? And to do that, you need to look at, there's a document you can get from CPP called the Statement of Contributions, which shows the CPP contributions the person made and in what years. And you need to learn more about CPP disability. And at some point, you'll be able to look at it and say, okay, when was it? They need to have there's 2 rules. They need to have valid contributions in 4 out of the 6 years prior to their deemed date of disability. Deemed date of disability doesn't mean the date of application necessarily, because a lot of people are disabled. They hope they'll get better. Of course, we all hope we'll get better. She tried to go back to work. She wanted to go back to work, but at some point she talked to her doctor and they decided, no, you're disabled from working. And that, you know, so there may be medical evidence to show that she was disabled, you know, say 2 years ago. And if that's the medical evidence, then the test would be, did she have valid contributions in 4 out of the 6 years prior to that date? Another little CPP tip is there's a twist. So folks that have a long earnings history in Canada, if you have 25 years of contributions to CPP, 25 years or more of contributions to CPP, you only have to, your contribution test is a little different. You can qualify for CPP-D if you show you have 3 years of contributions in the 6 years prior to your deemed date of disability. So 3 years of contributions instead of 4. It's a little easier to meet that test if you have a long work history.
But there's one other benefit we haven't talked about yet. It sounds like her CPP-D might be big, but there might be one other benefit that is still advantageous to apply for. Yeah, whatever path it takes, you probably want to get to PWD. However you do that. And in terms of the order of applying for the 2, what would be the advantages of trying to get that PWD application in first? Medical services. That's right. You get that PWD application approved. Sure, her CPP-D might come and wipe out all the benefits if it's a big one, but she preserves those medical benefits. There's no medical benefits through CPP-D. You know, so as Allison mentioned, there's a lot of value in those medical benefits. So, so getting onto the PWD first, then getting the CPP-D in place after may have some advantages. Yep. Yes. So fortunately, PWD, the asset exemption is quite high right now. It's $100,000. So with $7,000, if this were regular income assistance, I think it could be an issue. But
I'm going to jump in a little bit. I heard a lot of hesitancy in the room about, can she apply for income assistance, a PPMB? Nobody's jumping to PWD, and I'm wondering why that's the case, because we know her disability is quite severe. It's probably severe enough for CPP-D, which is a high bar to meet. So I'm guessing that sometimes people think you have to apply for income assistance and receive income assistance before you can apply for disability assistance. That is not correct. You do need to be on income assistance. Yeah, it is not correct. You can start with an application for disability assistance. Now, it takes time. For those of you who have seen that PWD application, how many pages is it now? Lillian, 20 pages, 25. So it takes a while, and you got to get medical evidence. So I'm going to say two things. Sometimes you may want the person to go on income assistance first, just because it's a faster source of some income. There's a little trick in this fact pattern, because who can tell me the current asset exemption level for income assistance? If we just want to get her some fast money by putting through a quick IA application, is she eligible? The issue is that the current asset exemption is $5,000, and she has assets of $7,000, but there's a solution to that. So if the ministry is satisfied that somebody has a genuine intention to apply for PWD, they can let them on to income assistance even though they have assets at the higher disability assistance PWD rate. So here, you could go get her in, try and get her in quickly for income assistance so she's got some money to pay the bills. Say to the ministry, look, I'm helping her with a PWD application, and we're going to apply for CPP-D. She's seriously ill. She has a genuine intention to apply for disability assistance. Her application for IA with assets at that somewhat higher, she's slightly above the IA level. Let her application go through, and she should be able to receive income assistance, while you can take the time then to properly put together her PWD application without such a sense of urgency, because at least she has some money to pay for food and rent, some rent.
Got logged out.
The question is it better for her to pay $2,000? If she has bills, she could just pay $2,000 of bills to bring herself down to the regular IA asset exemption rate. I mean, she could. Is that what she wants to do with her money? It's not necessary, because there is a rule within the employment and assistance legislation saying that she can have assets at that higher DA rate even and get income assistance, because she's pending PWD. She has a genuine intention to apply for PWD. Someone online asked if she would be collecting hardship assistance. No, hardship assistance is for people who are not eligible for regular assistance for specific reasons. In this case, I don't see any reason why she wouldn't be eligible for regular income assistance. Colleen? Sure. There's a question saying folks have been doing income assistance or welfare work for a while, and they've had issues where the EAW has refused to give out a PWD application form unless the person is already on income assistance. All I can say is ministry workers make mistakes, and that there's training issues, and they have a lot of new staff lately, and issues tend to be cyclical. So this was an issue like 10 years ago. People had trouble accessing the PWD form. And advocates did some work on that. There's actually a chart that exists that I'll post on the POVNet welfare list as soon as I remember to do it, that outlines the financial circumstances in which somebody should be given a PWD application form. Basically, they can show that they're financially eligible for disability assistance. They should be given a form. So if they have assets of $75,000, they can apply for disability assistance, because that's below the PWD asset exemption level. Kayla? Ask for it. I'm hoping that person is on the POVNet welfare list because I will post that chart. I can't well, next week I will post it. And hopefully if I don't, someone can post and remind me.
What time do we go to?
15.
Till 12:15. Okay. Well, we'll keep plowing ahead, although I guess at some point we may have to skip.
Yeah, this is, as we said at the outset, this is a complicated presentation and there's a lot of content. I think it's better to make sure you're keeping step with us as we go through rather than racing ahead and losing everybody.
Yeah.
Because we can always present the rest of this in a post-conference Zoom.
Yeah.
So make sure you're asking their questions because they're good questions. There's a lot of misunderstandings and complicated rules.
Okay, so the next benefit rub we're going to look at, we're going to take PWD out of the equation and we're going to look at the rub between CPP disability and EI. So as a starting point, it's one of these simple but not so simple cases. Quite simply, they don't deduct from each other. There's no deduction, but there's a catch. What's the requirement to get on to EI? Working. What's the criteria to get onto CPP-D? Not being able to work. So on the surface, you can see where the problems start to arise. If you're saying to one benefit program, I worked enough to get your benefit, and you're saying to another one, I can't work at all. Now, so importantly, CPP-D doesn't require no work at all. That's not the test. It's regularly pursue substantially gainful employment. So for given the requirements for 700 insurable hours, it is possible that someone could do on CPP-D could do enough work to qualify. So, but again, it's going to trigger some problems where at some point the income is going to be high enough that you're going to have to report to CPP-D. And what's the threshold? It's is it? Oh, there it is. Okay. So while on CPP-D, you have to tell CPP-D if you have more than 6,400 gross. So if you've worked enough to qualify for EI, you might well be reporting to CPP-D. If you earned between 6,400 and about 17,000, you could get reviewed. It's not automatic, but they're going to take a look and say, okay, are you really incapable of substantially pursuing substantially gainful employment? If you go over that 17,000 cutoff, you're done. They're gonna yank your CPP-D. So yeah, so in terms of the interaction between these two benefits, really what it comes down to is the problem of one benefit being for working, one benefit being for not working. So you just navigate these ones with caution, I would say.
Yeah, I'll just jump in and say it's important to understand, like when we talk about PWD and income assistance, we talk about earnings exemptions. And they are actual earnings exemptions. It's a quick calculation for the ministry to say, you earn $600. Well, we'll make it for income assistance. Somebody earned $400. It's below their income assistance earnings level. That means that, you know, there won't be any deduction from the benefits the next month. CPP doesn't work like that. It's not like they look at your earnings from 1 month and reduce your CPP check the next month by the amount that you've earned or anything like that. No one can tell you with any clarity what absolute dollar value of you can earn and still remain qualified for CPP disability. Because the test for disability is, does your unique and personal disability, prevent you from regularly pursuing any substantially gainful occupation? It's a bit of word soup, right? But it basically is, are you disabled from earning a substantially gainful wage. What's considered substantially gainful to you or me doesn't matter. CPP has its own sort of interpretation of what that means. And frankly, it's really out of date with wages and cost of living in today's economy. But it is that range. If you're in that range of income from 6,400 gross to 17,610 gross, it's indexed to inflation, so it changes a bit every year. But if the person earns in that range, they risk CPP doing a file review and reassessing whether or not they're really still disabled according to their own definition, which is tied to the ability to regularly earn a substantial, engage in a substantially gainful occupation. That takes time. It's not a quick determination. It's not like the ministry saying, oh, you earn $600, you have a $500 earning exemption, so next month you get $100 less. This takes time. There might be someone in the room who can tell me how long it takes on average. I'm looking at a couple people in specific, but I'm not seeing any heads nodding. I think it's months. It's months. It's easily months because it's a medical assessment of this person made this much money. There's arguments that need to be taken into consideration about, well, maybe, you know, they had what's called a benevolent employer that like worked around their schedule and dealt with the fact that, you know, they had a cyclical disability, which meant that maybe they could only work 2 days a week and they never knew ahead of time which 2 it would be. It might mean that, well, you know, maybe they used to be a lawyer and when they work, they're earning like a large amount of money per hour because they work in the private bar, not like Kevin and I. Oh, yeah. So actually that earnings, maybe that amount of income doesn't reflect a lot of work. You know, maybe they're only working 2-3 hours a week and it doesn't actually reflect a lot of hours and capability to work. Can you clarify that anymore? I feel like I'm not being the clearest.
No, it's a gray area and your clients just kind of got to live with it if they're going to pursue the EI and working. We can skip that fact pattern, I think. Okay.
Can you flip this slide?
Oh yeah, right. Okay.
So now just to throw more complications into the matter here. So it's also you want to look at the fact that somebody who, as we gave examples, there's reasons to be on. So first of all, the ministry can force somebody on PWD to apply for CPP disability as well. And if their CPP disability rate is below the PWD rate, they'll be on both benefits at the same point in time. But there are contradictions between CPP and PWD. They have different, and the main contradiction is to do with earned income. So if you're on PWD and you're single, you have an earnings exemption up to $15,000 per calendar year. That's basically net income. You have to report your earnings to the ministry, but as long as you're below that $15,000 threshold, you continue to receive your PWD on a monthly basis. Of course, we've just learned that that's not necessarily the case with CPP-D. That if you're earning up to 15,000, say you're earning 12,000, you're on PWD, ministry has no problem with you, you're reporting everything, it's great. CPP, on the other hand, may have a big problem because they may look at you and say, oh, you're earning $12,000 a year. We need to reassess whether you're still disabled for our purposes. And they may go ahead and do that. And it may take them quite some time to do it. And, you know, 12 months down the road, you may be told, let's say I'm the person concerned here. Oh, Allison, you know, now it's October 2022, and we just reviewed your file because you had a bunch of earnings last year. And we're here to tell you, we don't consider you to have been disabled since June of 2021. So you have an overpayment for all of the CPP disability you received from June of 2021 till now, when we're finally just telling you about our decision. And moreover, you're not eligible for any CPP disability going forward. So remember, I'm also on PWD. So I'm not too concerned about not getting CPP-D going forward because I know I still have my PWD benefits. I'm like, okay, well, I'll still receive the same amount of money that in each month, only this time it will all come from the ministry. But I'm very concerned that I have to pay back thousands of dollars in CPP disability as an overpayment that they're saying I should have never got CPP disability from last June till now. I think all we can do here is flag the problem, because this is there's no clear answer to this situation. It's becoming increasingly common because ministry earnings exemptions have increased over time, and CPP has not changed the range of income it allows people to make. I mean, it's indexed to inflation, but it has not substantially increased. To give you an example, PWD earnings exemptions 2012 were $500 a month. Now, if you divide 15,000 into months, it's about $1,200 a month, $1,250 a month. So it has more than doubled. It's increased 250% in the last 10 years, whereas CPP, the range of income you can earn, has like increased maybe 2 or 3%. I don't know. Inflation was low before. So Kevin and I have been wrapping our minds around this problem, and there's no easy answer. But, you know, if you think about it, someone with a CPP overpayment in that situation actually never received that money from CPP-D, because in a way, it all got deducted from their PWD benefits. So if we say they had never received that money in the first place, they would have just been getting regular PWD. So in a way, if you look at it, you can look at it as the ministry received the full benefit of those CPP disability benefits, because saved them money. They didn't have to pay out the full PWD rate to the person. And yet now the person is being asked to pay money back to CPP disability. So we think there may be a couple of ways to try and approach that, to try and rectify the unfairness to the person. Maybe you can ask the ministry to assess an administrative underpayment once you have evidence that you have to pay the CPP back to the CPP program. Maybe there's an appealable issue about having had your PWD benefits reduced due to CPP income that you're actually going to have to pay back. At the end of the day, I think the ombudsperson's office might be a good remedy for this systemic issue. It's a systemic issue. I don't know if you've heard much talk about the ombudsperson's office. They're created by the Ombudsperson's Act, and basically have the ability to investigate government, mostly government and quasi-governmental situations where there's concerns about procedural unfairness, or there's a concern that some action has been arbitrary, oppressive, or discriminatory, or has been taken under a procedure that's arbitrary, discriminatory, or oppressive. And I think this procedure results in such unfairness to the client that they might be interested in complaints. So I think all we can do is flag the issue and say, if you have clients in this situation, reach out, call me, call Kevin. There's probably remedies, and it probably won't be a quick fix, but that as a group of people, I think we're going to be seeing more and more of these. If you're at the plenary on Tuesday morning, Ashley Silcock, who does all the CPP advocacy for Disability Alliance BC, said she's seeing more and more and more of these overpayment, CPP-D overpayments for folks that are also receiving PWD.
Did everyone follow how the client's being asked to pay back money they never got? Like, right? That's the idea. I didn't get the CPP-D. The ministry got the CPP-D because it's signed over to them, but who has to pay the debt? So now they're actually paying back tens of thousands of dollars, not of money they got, but money they didn't get, that the ministry gets. And the ministry's sitting there laughing. So, yeah. Sorry, the question was, could you protect from creditors, because PWD normally can't be scooped by creditors. And that's true, but it doesn't help the client in this case. It's true that CPP-D couldn't scoop their PWD benefits, but the client is still sitting there with a massive debt on their hands, and the federal government can scoop all kinds of other benefits and income and really make life miserable. Again, trying to collect this money the person never got. They're repaying the ministry's
Yeah,
debt.
I
So-
heard it framed a little differently. I thought you said CPP is protected money. Oh, okay. Okay. It's also true that CPP is protected money, but CPP can collect CPP benefits back from the person. Question. Yeah, there's all kinds of problems that can arise. So the comment is that knowing all of this, and then you're seeing this as an advocate as well, you feel like you should almost dissuade people from applying for CPP disability. The issue there is if they're on PWD, the ministry can require them to apply for CPP disability. And, you know, if it's somebody that isn't working or is working at a minimal level so that their income is below $5,000, $6,000, $7,000, it probably won't become a problem. But for people who are more able to utilize a higher earnings exemption with the ministry, it can very much become a problem with CPP disability. But yeah, you can warn your clients. I mean, the other problems can arise here. There's sometimes a lot of confusion. Generally, people on PWD understand that they need to report their money to the ministry. The ministry's communication about that is pretty clear. CPP, not clear. Lots of people don't understand that they have to report their income to both places. I think that Ashley's been doing some work on a committee trying to get CPP to be clearer in its communication so that folks understand that they need to report to CPP about their income, and they need to do it separately in addition to the ministry, because not reporting creates a whole bunch of other problems too. Basically more that it's more likely that you'll get a larger overpayment if you were working and didn't report to CPP-D because they find out about it further down the road.
Okay, this I will do very quick because it doesn't come up that long. Worker has a work accident. They're entitled to both WCB and CPP-D. What's going to happen? And again, this only applies to those permanent disability benefits I'm talking about generally. So what's going to happen is you're going to get you're going to get your CPP-D. WCB is going to deduct 50% of the CPP-D benefits. Why? And this may change very soon. Here's the logic. WCB is completely funded by employers. You don't pay premiums for it. CPP-D, both you and your employer contribute. So what they're basically saying is, because both you and your employer, you get to keep half the benefits, which roughly corresponds to the contributions you made as a worker, but the employer, because they covered you for WCB, doesn't need to pay twice. Go figure. I think it's going to change real soon, but it doesn't come up very often, but that's how that works.
Okay, we only have 5 minutes left. And this is the start of another section of the presentation, really to do with seniors benefits. So I'm almost thinking that it would be smarter to do the remainder of the presentation separately on Zoom another day. Sure. And leave the 5 minutes now for questions and discussion, because we've covered quite a bit of material already. And I don't want to overload your brains. I know that third day of the conference are most of us suffering from information overload already. So if that's okay with folks, let's take the last 5 minutes and have some question and answer period.
And if you have questions about seniors benefits, we're happy to try to deal with them too.
First, do that from the online and U.S. It used to be if you wanted PWD, you had to get special book with stamp and number, so you already had to be on a system. But now, like to prove who you are and do all that, I don't know how that funnels.
Sure. And I'm going to throw this question to the room because, so the question is somebody who used to do advocacy a while back. And it used to be the case that PWD application existed only on paper and you had to get it from the ministry. Question is, can you now apply for PWD only through My Self-Serve? Yes. Yeah. Yeah. Lillian? Right. Yeah, you can, yeah. So the consensus seems to be people are coming in generally with the paper application. Perhaps it can be, once it's filled out, perhaps it could be submitted through My Self-Serve. I'm not sure about that. I don't, I don't have, you guys are I work with you folks. I don't have clients where I can look at My Self-Serve. It's a bit of a mystery to me. All right. Okay. So I think I can. Okay. So you do have to make an application to the ministry. The ministry has a 2-stage application process. So if you want to apply for disability assistance, first the ministry will take your application. They're going to assess, do you meet the financial eligibility requirements for disability assistance? Are you potentially eligible for disability assistance? They'll look at that. If the answer is yes, then you'll be able to get the PWD application form. You do not need to be financially eligible for income assistance first. So remember, these are terms of art, right? Income assistance means benefits of 560 support plus 375 shelter in a month, very low rate, low asset exemption level, low earnings exemption level. You do not have to meet those criteria in order to be able to apply for disability assistance and the PWD designation. But you do have to have your financial circumstances. You have to contact the ministry, have that initial interview, have your financial circumstances assessed. They will say, yes, we think you're potentially financially eligible for disability assistance. Here's your PWD designation application. If you fill that out and it's accepted, then once you have the PWD designation, your disability assistance would kick into pay. Does that make sense? Okay. Other questions?
It's just all so clear. It must be, yeah.
It's 12:14. We have 1 minute left, folks. Okay. Well, I'm pretty sure lunch is, question. Yeah. The question is, if somebody's applying for income assistance and it seems like it should be obvious that the person is disabled and would want to apply for disability, PWD designation rather, should the ministry be applying the higher disability asset exemption level? They should be, but I wouldn't really rely on a ministry worker. You can't assume that they are. You can't assume that they are. So you always want to, like if you have a client in that situation and they've been told that they're not eligible for income assistance because their assets are too high, you would want to go back to the ministry and ask them, like, why was this turned down? This person clearly wants to apply for disability assistance and I'm going to be helping them do that. You need to apply this higher asset exemption level. There have been a lot of recent hires at the ministry, and there have been a lot of new advocates hired as well recently. So particularly with new ministry workers, there can be training issues. They may not understand the legislation and rules correctly. As you know, they're complicated and there's a lot of them. And I know for advocates, particularly when you're new, it's hard to have that confidence to say, oh, I understand the rules better than this worker, or I have the confidence to second guess what's going on. So you have resources, post your situations to the PubNet welfare list. I would say there's lots of senior folks on there who can weigh in and say, no, you're absolutely right. And can direct you as to the right way to go. And I'm on that list too. So we can continue to share information as we go forward. And I'm going to see if I can round Kevin up to continue this presentation another day on Zoom. But for today, thank you very much for coming and paying such close attention. And now it's lunchtime.
Thank you, everyone. Great to see everyone.